Greetings, dear viewers and listeners. My name is Igor Zoenko, and I represent the media department of the Crossroad new project. For those unfamiliar with us, I will explain who we are. The Crossroad is a team of young game developers residing in Groningen who organize quarterly networking events for anyone interested in meeting game developers on Groningen. I myself moderate the talk sessions of these meetings. This is our new media project dedicated to promoting and highlighting Dutch and Groningen game developers. And today, our first guest at the Crossroad is Sharif Ibrahim, attorney at law, who works closely with Dutch companies in our industry. Hey, Sharif.
Hi, Igor. Thank you for your invite.
Thank you for coming. So let's start with a little introduction. Can you tell a bit more about yourself and your work?
Yes, my name is Sharif Ibrahim. I work at Taylor Wessing in Amsterdam. We are a European-based law firm. We're in the Netherlands, based in Amsterdam and Eindhoven, and we have other offices as well throughout Europe and abroad. I've been a lawyer since 10 years and a gamer for even more years. I once started with the SNES and also the Nintendo 64, which may seem Asian to some people. And since a couple of years, I've started focusing on gaming as well. So involving my hobby into my work. So I advise gaming publishers and other gaming related companies on the various type of issues.
Mm-hmm. When we first met at the Indigo conference in Rotterdam, you told me you are a game lawyer. And what would you call the most intriguing part of the game development from the point of law for you?
That's a difficult one. It depends on what perspective you look at. But I think the initial phase, like from a legal perspective, is, and that's not only exclusive to the gaming industry, but actually in all of tech, making good appointments with each other, just laying down the foundations and writing that down. Also with the perspective of you trust each other, but still you need to have something in place for when something goes down and you don't trust each other that much anymore.
Mm-hmm. Okay. And I want to ask you a few questions about your background. I looked through your page on LinkedIn, and I was very interested in your studies. And I saw that you dedicated all your studies and all your work to intellectual property. And when exactly did you realize that you want to specialize in this part of legal life?
Actually, very on from the start on. I indeed started as an intellectual property lawyer at a bigger Dutch firm, and we also had to do this 1.5 years of intellectual property and 1.5 years on this transaction department. So what I then did was finance and restructuring, and that part helped me in understanding the financials and deal mechanics of the law, but I did know that I wanted to go back to intellectual property, and I'm now focusing more on that part together with the tech and data side of the legal work.
Yeah, financing is a big part of game development industry.
Yeah, certainly.
And since then you worked in many different companies, but I've read your positions and they all were connected to the topic of intellectual property, at least somehow.
Yeah.
And was the game industry your preference already back then?
Yes, but there weren't that many companies who or law firms who dedicated their resources to it. And luckily here at Taylor Wessing, it's different. We have quite a strong focus on the gaming industry. Also, our UK colleagues are very active in the scene. And I am in the Netherlands. I'm setting up our gaming practice from a Dutch perspective. And we're doing more and more work. And also, more in the international spheres, because of course video games are not confined to a certain border. So the nice part of it is I have international colleagues who I can also confer with, but we also refer work to me, and the other way around. So that's very nice. And on top of that, we also have, as you know, the gaming industry from a legal perspective is not confined to one specific type of law. It involves
Very true.
It involves, for example, when you talk about funding, finance and M&A, but also employment law, for example. And I focus more on the technology side of it, and things like software copyright. And I have colleagues who can help me if I need additional expertise.
Yes, I researched a bit on your company, Taylor Wessing Benelux, which I guess is just a branch of bigger Taylor Wessing, judging by the fact that you have colleagues in UK, right?
Yes, in some sense it is.
Okay.
But compared to, for example, other larger firms, we were originally a Dutch law firm who merged together with the bigger Taylor Wessing group of law firms, and that makes us, in that sense, a bit different compared to the traditional really large firms. That we act for both international clients as well as local Dutch clients.
Yes, I think that it makes sense for gaming industry, because game development industry probably is the most easiest to diverse themselves into an international market, because games do not restrict themselves with physical copies. Mostly games are sold in Steam, which are digital copies, also in PlayStation Store or Xbox Store. And yes, I think it's very important for everyone to perceive themselves not as some country-based studio, but as an international studio from game development perspective. And as you mentioned, you work with publishers, so they are your usual clients. But what is that usually you are making with them?
I assist a wide array of clients, not only publishers, but also platforms or developers, and it's a broad range of things. A bit of publishing agreements, but not that much really. A lot of consumer protection issues. So lately, there's been a lot of the CPC, this International Cooperation of Consumer Protection Agencies, and there are a lot of legal questions arising around, for example, the sale of in-game items. When can you do that? When is it considered misleading? And mostly those kinds of things. And we also handle software development agreements, for example.
Okay, and
software copyright issues.
So you mentioned consumer protection, and you said you mentioned the misleading cases of consumer goods in games. I mean, the monetization in games. So would you consider a consumer product misleading if it is made like in such popular games as Genshin Impact, where mostly the progression in game, the true progression, is based on getting characters from sort of casino, but without the real money in it, except for the donations, of course?
Well, it depends on how it's presented. So you, of course, have the typical loot box type issues, and loot boxes have been a thing a while back in the Netherlands. It's a bit more quiet on that front right now. And one of the most important elements under Dutch law is that the items you get from loot boxes is that they are exchangeable for real money. And in most cases, it's a bit of a general statement, but in most cases, when you cannot exchange them for real money or trade them on a platform, it's not a classic illegal game of chance. as other countries. In some other countries, for example, the stake is a requirement to qualify as gambling. In the Netherlands, it is not. But the other element, which I just mentioned, is indeed the exchangeability of the item. So if it's exchangeable for real money in an easy way, or exchangeable on a platform, it is more likely to qualify as a game of chance. And you see those loot boxes. But another element of this practice is, for example, the display of drop rates. In most games, the drop rates should be published just to be transparent about what you're getting and under what conditions.
Yes, I may be wrong because I don't remember, to be honest, but I think it was the Netherlands, I think 5 years ago or something, that planned to at least consider an option of prohibiting loot boxes in games. Am I correct?
Yes, there have been talks about it, and also in Belgium and other countries. For example, Germany is busy as well. But I think it seems that the priorities of consumer protection agencies have shifted a bit more to a different area. I must say that I haven't heard about loot boxes, like from a legal perspective, in games very lately anymore.
Yes, true. I think maybe we diverted into a different perception of the loot boxes, because I don't think many people right now have loot boxes in games like in this old-fashioned way of the older game development industry. But all right, let's imagine a situation. So, for example, I am leading a small game development studio, which is willing to sign a contract with a publisher, but I'm not very sure on the legal matters of this agreement. Is it possible for me to, as a client, come to you and ask for some guidance on the law part of this agreement?
Yes, of course. Yeah. It's good to get this advice, because what you also see, for example, with young musicians, sometimes they're represented by family or friends they know, or people who are not that much into the legal sphere. And I would really recommend getting some advice or doing a lot of research, because nowadays there's a lot of guidance available to help you navigate. But of course, indeed, if you're a publisher, we also offer our advice to publishers, to indies as well, game developers.
You may not be able to tell me, but just to be clear, is the price for this such consultation fixed, or it depends on the size of the company, of their income size and such matters?
Well, it really depends. There are lots of different ways in which you can structure it. Nowadays, what you see more is the standard thing with legal advice in the past was that it was paid per hour, but for certain elements, some fixed price arrangement can be made, and there are also various other alternatives. I also advise some clients on a pro bono basis, either because they're connected to a university or are into research. For example, educational games are more likely to be able to, for example, to get grants, or if they are developed for like a public matter, there would be a use case in doing that for on a reduced fees base. So that you can always, not only for me, but also other legal providers, it's always possible to negotiate some kind of alternative arrangement depending on size and goals of your game, for example.
All right, and let's proceed further. I've read that your master's degree thesis was called, and I may be not very correct from the translation point, it was called Uncertainties in Property Law, right?
Well, my master's thesis was actually very unrelated to games, and it was more focused. To be honest, I was looking for a very specific, a very special subject, because I heard all of these typical master's thesis examples, and I was looking to do something which is a bit more strange, so to say. So at one point in my during my studies, I heard this thing about satellites and securing property rights on those satellites. So
yes, it's very interesting theme. Do you know that actually in the late 20th century there was an auction for property on the moon, for example?
yeah, true. Yeah, there is this new initiative from the European Commission for European Space Act. They're working on this now, and it's a very interesting subject to think about. It also has a bit of my fascination with space and this specific thing about not go into the boring legal stuff, but basically it is possible to, for example, if you buy a car and you want to finance it, a bank may put this right on the car, so that when you stop paying, they can take the car back. Very, very generally speaking. And the same you can do with a satellite. But the thing with a satellite, there are many peculiarities with satellites. For example, when they go out of course, they might crash, then they are worthless. Then what do you do with this right you have on the satellite? And the question is also whether a satellite is just a normal good like a computer or anything that's movable, or whether it is something like a ship which is registered, and if it's registered like that, it can qualify in the same category as for example a house, and then you have a whole different legal regime which applies it. But let's not get too much into the boring legal stuff.
I would really love to listen, hear about that, honestly, because I completely share your fascination with space. But yes, we probably should return to the game industry matters. But the reason for me asking you about your master thesis is that I think that the legal relations between the buyers and the studios and publishers in game industry are very interesting and strange in some way. For example, there has always been, since the beginning of mass digital distribution of games and the services like Steam or PlayStation Store or any other game distributing digital service, a great misconception about players' ownership of video game. Because in fact, none of the players own their games in common sense. I like to quote a Steam license agreement. The content and services are licensed, not sold. Your license confers no title or ownership in the content and services. And from the legal and moral, actually, way, how do you explain the existence of this type of license?
Well, actually, to be honest, it has always been like this, more or less. The only difference between like 10, 20 years ago and now is that in most cases there is no physical aspect anymore.
Yes, of course.
But back in the days when you just bought a CD or a floppy disk, you also had a license to use the content, but you cannot do, for example, you cannot copy it or reverse engineer it. And if you maybe some of the listeners will remember that when you installed something like physically on your computer, you also had to click through this and use this EULA, this end user license agreement, which is practically the same as it is now, except for the fact that now you don't have a physical copy, a physical copy of the software which is licensed to you. The same thing, for example, with things like Photoshop back in the days, when you installed it on your computer. Even though you had this physical cartridge CD in which you install it on your computer, still you were only licensed to use it. And it's actually quite funny. If a friend of mine is doing his PhD on this very topic, like the ownership of games.
Oh yeah,
I can give you the link later, but it's an interesting subject, and it's also more of a philosophical debate which you can have to whether is fair or not.
Mm-hmm. But the reason I'm asking about this is that this license agreement presumes that the license can be discontinued at any moment by the will of the ownership of the true owner of the license, the true owner of the license. So, and there are actually examples of that. For example, one of the Settlers game, if you know the series of games Settlers, was taken away from Steam and maybe other platforms by Ubisoft, even from people who have paid for it. And do you think that studios, publishers, and distributors are somehow responsible for the existence of this misconception?
Yeah, I understand the question. I also read some messages about it, indeed, and of course, it's in the end, it's the party who publishes the game and operates it who can decide, well, so to say, to pull the plug. And I do understand the concerns, because if you bought a game, you would want to play it, and back in the days that was possible. Although with the same thing, if I do the same parallel with Photoshop, the same could happen as well, that discontinue services. But it is a difficult topic, and it's also something which, of course, since the transition from physical to digital media, has gotten more and more present. And yes, you could argue two ways. On the one hand, with live action service games, it's a bit difficult to perpetually provide the services. On the other hand, if it's a standalone single player game, it's sensible to assume that you can play it anytime you want. And I think even in the not so distant past, there were some issues with some games requiring certain accounts and to be online to be able to play them. It is a difficult philosophical question, and you don't see it only in games. You also see it in all kinds of other software, and we also deal. So I don't only focus on games. I also focus on software disputes in general, and you do see it a lot. And I agree, it's somewhat confusing, and of course, since games are sold to relatively young people, not everyone will. Well, practically no one will read the full license agreement that you sign. But look, technically, legally, from a legal perspective, it could be possible.
And yes, I cannot avoid this question. Have you heard of the initiative, the European initiative about saving games? That's what you said about, to those unfamiliar with this topic. It's an initiative which I'm not sure at which stage right now, but I saw that it had got a lot of petitioners. I think they even passed the amount that it's required for the European Parliament to take it into consideration and vote for it. It's an initiative that, if it's accepted, makes the companies to create games in a certain way that even after the discontinuation of the support or server support, the games will still be playable. And myself, I am not exactly agreeing with this act, because of course that's what you said. Live service games, any multiplayer game which doesn't have any single player regime mode, I mean, and which is not possible to play without server support. It's not easy to make this work for such games to exist.
Oh, true. And games are also dependent on a large player base.
Of course, yes.
I actually remember it's a while back, but you had this the original Half-Life. It had like many mods, among which one was Firearms, which was it was a great mod to play. And maybe the older listeners will recognize it, but it's quite a while. But at one point, people merged to Counter-Strike 1.6, Source, and so on. And yeah, it is inevitable. You do have some initiatives of retro gamers who host their own dedicated server and then play the older games. And if that's possible, then it's nice, but it's more of a nostalgical feeling compared to the whether it's actually possible to maintain it. And in that sense, initiatives like conservation of games are quite good. For example, the Dutch Museum for Beeld en Geluid, it's called, so for sound and vision. They have this great initiative of conserving Dutch games. I've met the people who work on this a couple of times, and it's very interesting to see how they do it. So what they do is they contact game developers and ask them whether they have for their permission to conserve certain Dutch-made games. And of course, you're dependent on certain hardware platforms or other media. And then what I've understood is they also use, for example, emulators to be able to play the games independent of the technical availability or technical availability of hardware or networks. So that's a great way to conserve games. But I do agree. It is on the one hand, I understand the sentiment that you want to purchase a game and want to be able to play it in perpetuity. And for some games, this is possible. But for a large amount of games nowadays, technically it may be possible, but practically it isn't. And it's difficult to balance that.
Yes, I actually understand the developers and even big corporations, because, for example, for operational system Windows 10, NVIDIA will stop producing new drivers since I think that either this autumn or the next one, not sure about that. And I think it makes sense because the development progresses, the technology progresses, and you cannot always support older versions of the software. But I also understand people who are willing to have what they've paid for their life.
Yeah.
And all right, another question I would like to ask about that. And of course, you know what is NFT and non-fungible token, right?
Yeah.
And as I see it, I may be wrong, the current problem with ownership of games is that, with digital ownership, I mean, is that you do not get a physical product, which is unique. You get a digital copy, which is not unique. But non-fungible tokens allow to make a digital product actually unique if you add them. And do you think it is possible to switch to, at least partially, to the actual ownership of a digital game copy by somehow implementing the non-fungible tokens in the architecture of game copies? I'm not asking for the technical details. I'm more interested in legal precedent, maybe.
It's a difficult one because NFTs are also a very difficult legal topic, and they have been quite. It has been quite popular a while ago.
Oh yes.
Nowadays, with the AI Act, attention has really shifted more towards that. So and for in part, it's also a bit out of my expertise whether that would be technically but if there would be more legal clarity about the status of NFTs, perhaps it could be a way. Of course, you had the license keys back in the day, but that's a very easy method to circumvent. So if there would be more legal clarity about the status of NFTs, and also not only in the Netherlands but cross-border, because you would actually have to have a very uniform legal status or legal definition of NFTs, not only within Europe but all across the globe, and that's very difficult to achieve. So I think that's one of the major issues. What would at this point in time make it harder to use NFTs as means of identifying individual copies of games.
Yes, and it is actually very difficult for the games because, as we mentioned before, games are an international product, and it's very difficult to, that's actually my next question, it's very difficult to defend your rights as a consumer and buyer being in a different country from the provider of this game you buy. So, and we see nowadays that the disturbance in the world actually rises, and the global market is maybe not still shrinking, but changes at least. There is no clarity about the future. And how do you think, is it still, I mean, was it ever actually possible for a consumer from, for example, Uzbekistan to defend his rights against a company from such a company as Steam, for example, if he thinks or she that his rights are breached? Is there a legal mechanism for him to defend himself in the court and finally at last come to some sort of resolution?
Well, in general, for consumers, it is possible to exercise their rights under the laws of their home country. So there are, I don't know whether all states are part to those conventions, but there are conventions at least in Europe, but also for most other countries, you have these treaties about jurisdiction, and for consumers, the country of the residence of the consumer, that's the country which the applicable law applies to if there is a dispute between any professional party and such a consumer. So yeah, there is a possibility for consumers to do that.
Well, let's hope it will work out for those concerned. And switching to another topic, which I also cannot pass by. When I first planned to approach you for an interview, a big event in the game development industry happened. And when we, with you, discussed the upcoming interview, I said that I will ask you this question. A month ago, MasterCard and Visa started to pressure digital distributors such as Steam, the biggest distributor, and Itch, which is mostly for indie games, mostly free, but sometimes not, started to fiercely push them to make them remove adult content from their markets. This is a very long story, actually, continuing not only with games and continuing for a very long time, several years already, but this is a new tone of it. And obviously, it's understandable that the payment operators do not wish to be associated with potentially questionable content. But I think we face a very interesting problem here, mostly from the legal aspect, and I hope you share my concerns. We de facto live in a world with the existing duopoly of two payment operators, MasterCard and Visa. You will hardly find any bank in Europe on most of the other world, except for such countries as America, where there is American Express and Union Pay in China, where you can find a credit card that will be issued with a different payment operator than MasterCard and Visa. And even such payment operators, digital, I mean, like PayPal and many others, they also work through MasterCard and Visa architecture. So, as a man with huge background in this section of law, how do you classify the situation when corporations use their position to restrict certain type of content which is legal in the countries of their working sphere?
Yes, I'm quite actually familiar with the issue, and it does not only extend to the credit card operators, but also to banks. Just to name an example, in the present, I have assisted clients who, at one point, received questions about payment behavior and wanted to know more. Or even, there's even a story of a lawyer receiving just his fees from a client who has been put in the news in a negative way. And the reason why that happened is that this client, it was a company, the company was involved in a defamation lawsuit, and they were defended by this lawyer. And then, due to all kinds of AML, anti-money laundering, and KYC requirements, banks have to perform research. So they found this name of this client in a negative context, which is logical if it's in a defamation lawsuit. And then they thought, okay, well, this is suspicious. But on the other hand, the lawyer has a duty of secrecy. So
of course,
they cannot just give away the client's name. But then the lawyer had to say, well, that's just a payment for my fees.
Yes.
So I think this is, in essence, this is maybe a bit of over-regulation in the financial sector. Maybe for actually a personal example, I once bought this motorcycle bag from Germany. So this motorcycle backpack. And it was from a bank account from a foreign bank. And at one point, the payments got stopped, and they had questions about like €30. So I think it's crazy, but I hear this more and more in my environment, and also for a smaller consumer. So I think it's unfortunately it's not a problem exclusive to games. It goes much further. It goes also to businesses, and it is a combination of moral questionability of how the payment service operators operate. On the other hand, I do understand that there is a certain fear of these payment operators of being associated with such kinds of things and getting large fines, because that has happened, and they have been very busy in getting more and more personnel to do all the checks, but it's actually not feasible in a normal way to perform all this research without being too and I think what they're doing is being overly cautious instead of balancing on the line, which could expose them to big risks. So on the one hand, I do understand it. On the other hand, I think it is getting a bit out of hand with the margin of discretion that payment service providers have. And also, indeed, what you say, the problem is that there are not that many options.
Yes, of course, yeah. And I'm not sure about that, but as a legal man, can you tell me if maybe there are such countries as mostly as USA, because MasterCard and Visa are registered there, but of course other countries such as European Union and many others where they work, maybe they should add some clarity to the legal background of it, because of course such important and such big and widely used corporation as Visa or MasterCard, they just cannot check every single act of transfer, because it's simply impossible. Even if they hire thousands of employees who will mandatory check every transfer, it's simply impossible. No company has these resources.
No, true.
And
yeah, that's the difficult thing about it. But as I said, it is probably the result of over-regulation in this area. Because if you look at how financial law develops, and financial regulatory law develops, it's revision after revision after revision, and all kinds of sanctions, and just those parties in the financial sector have become very careful, maybe a bit too careful in some instances. But I do share the concern, and of course, if it happens, don't be afraid to just file a complaint about it, because it does happen that after complaining, things may get undone. But on the other hand, maybe the harm then has already been done. If your game is pulled for a couple of weeks or even months, the harm may already been done in the meantime, even if it gets back on the platform.
Yeah, especially if you're a lawyer who just has to perform his duty to defend the client.
Yeah, true.
And well, maybe some legal regulators should take a look at this problem, because I'm not sure if it's the monopolistic service that should take a look at that, but maybe some of them. What do you think?
Well, competition law is not my specialty, so I wouldn't know whether this would qualify as such. It would not be some kind of monopoly, but it may be abuse of a market position. But then again, the reason would be to comply with their interpretation of the law. So that would be a difficult one, I think.
Yeah, probably.
But well, like in all consumer cases, it does help to go to the regulator, which in the Netherlands is the ACM. If there is a concern about the payment, it could be helpful to just check the website whether there is something on there.
Yes, and this whole story with adult content started with the very terrible situations on pornographic services. But I think that the judge who was reviewing the case in America made a big mistake, because he, I don't know his gender or her, but she or he, they ruled out that Visa is guilty for servicing the these websites. But I think it's actually a big mistake, because of course Visa cannot check every client of theirs. It's simply impossible.
No, true. And then when you're saying America, there's this other thing about what is acceptable in which jurisdiction. Norms and values differ per jurisdiction.
Yes,
that makes it even more complicated.
It is very complicated.
And even legal requirements differ per jurisdiction.
All right. And to the final topic, I hope more pleasant to both of us. I think that none of those who work in game development industry cannot work there for long if they don't like games, if they don't find inspiration in seeing and playing other games, and from this experience driving power and move to work more on their projects. So what would be your number one game this year?
This or next year?
This year. Let's ask. I'll ask you both questions. Let's start with this year.
Yeah, it's difficult. Unfortunately, I'm 34 now, so I don't have that much time anymore.
Of course.
I actually just started playing Death Stranding, and it's I find it a very interesting concept. I also played through Horizon, both Zero Dawn and Forbidden West. I found that very nice because it has these relatively simple mechanics with the customizable crossbow with all kinds of add-ons, and like these boss fights in which you really have to think about. But of this year, I wouldn't be able to say. For next year, of course, GTA 6, because I've been a huge fan of the series, and one of the few games which I really make the time for. I remember standing in line for GTA 5 back in the day. But Death Stranding is a very interesting.
The second or the first one?
I started playing the first one, but I'll also be playing the sequel this year.
Yes, Death Stranding is a great game. I played it long time ago when it was released. I played it on of course I played it on the PlayStation because it was not available on any other platform back then. To be honest, I didn't like it that time because of the gameplay mostly. But nowadays I really want to replay it because now I have a bit different preferences for games, and I watched like all the cutscenes of this game on YouTube. It was like 11 hours video, and I loved it actually. I think it's a great game, and as people say in my country, Kojima is a genius.
And that's it's a very it's very engaging. The music is good, and together a very underestimated game which I still have to play, but I already have bought it is Mafia.
Oh
it used to be. I think it's very underestimated. I've heard the reviews are quite good. I have already downloaded it, but I haven't had time to play it yet. And well, it's a bit different compared to most popular live action service games right now. It's just single player, but it has been always a very like even the first one. I also played the first one, which was very nice back then. And something which I also look forward to based on the gameplay videos I've seen is 007 First Light. I don't know whether you've seen the gameplay video, but it's quite nice that they
I did actually
included also their experience from Hitman into this 007 themed game, which is, from what I've seen now, it really catches the 007 vibe with the over-the-top action sometimes.
Oh yes. Well, it's the same company, so they have a grand experience in this field.
Yeah, true. And for this year, and that probably Death Stranding too. And also started playing Baldur's Gate, but unfortunately, I just noticed that I do have. There are these types of games which are very good, but that you run the risk of, if I'm going to get into this, I'm going to spend a lot of time in it. And unfortunately, time has become a little more scarce compared to 20 years ago.
I understand.
But it's great as well.
Yeah, it's a great game. I played it. I finished it. I played on the lowest difficulty though, but I really enjoyed it.
Yeah, and Cyberpunk's the same. Very nice, very good game. But I still have to find the time to finish.
All right. Thank you, Sharif. It was a great opportunity to talk to you, and I hope that our followers will enjoy this interview as much as I enjoyed taking it. We are looking forward to creating more content for you, and we'll see you in 2 weeks. Thank you.
Thank you.